the Memorandum of Understanding. Before we begin this video, first we should think about the context of what we're talking about. Simply put, the academia, the brain of control today, operates from behind the scenes a multi-tiered system of corporations. So, most conceptualize a government as a group of individuals from the same families, the same area that everybody else is. Most also believe that a company should be run by a human being. That is not the situation that we're looking at today. And that's what the evidence is going to show here in this video, is that academia runs a multi-tiered system of corporations which own other corporations, and thus there is in fact no actual cognitive human head operating everything. And among those corporations are what we call government. They are in fact corporations run by other corporations, and ultimately, at least as far as the evidence suggests, the orders are being dictated from academicians who are hidden far behind the scenes. This mechanism is leveraged, essentially speaking, as a weapon. And when we read through these documents, we will see the perspective behind it. So let's get started. To begin with, we're going to start with another document from Eric, the education sharing system of the Department of Education, essentially speaking, if you will, the academia's classified materials processing center. MOU, Guidelines for the Development of a Memorandum of Understanding under the auspices of the Workforce Investment Act of 1998. Iowa State Department of Education, Des Moines, Iowa Association of Adult and Continuing Education Deans and Directors. This is from 2000, and the date here is rather written really oddly. Section 121 of the Workforce Investment Act of 1998, WIA, requires regional workforce investment records, RWIB, to develop a Memorandum of Understanding, MOUs, with the Regional Workforce Development Center, RWDC, partners to detail how resources will be coordinated across funding streams to operate and provide services for the RWDC delivery systems. So that's how they churn out these Memorandums of Understanding. This document is ED 438408 and CE 079692. Those appear to me to be confidentiality or classification markings. This lists workforce investment systems, adults, dislocated workers, youth, Job Corps, Native American programs, migrant and seasonal farm work programs, and veterans workforce programs. Guidelines for Understanding a Memorandum of Understanding for the Adult Education and Literacy Act under the auspices of the Workforce Investment Act, U.S. Department of Education Educational Resource Information Center, ERIC. Document has been reproduced as received from the person or organization originating it. Permission to reproduce and disseminate this material has been granted, and I can't read that name. Iowa Association of Adults and Continuing Education Deans and Directors, January 2000. Memorandum of Understanding Task Force members: Robert Wells, Chairperson, Indian Hills Community College, Ottumwa, Iowa; Barbara Stevens, Southwestern Community College, Creston, Iowa; Lynn Rolfsmeyer, Northwest Iowa Community College, Sheldon, Iowa; Pam Southworth, Iowa Western Community College, Council Bluffs, Iowa; Robert J. Schlingen, North Iowa Area Community College, Mason City, Iowa; and Nancy Cothan Butel, Eastern Iowa Community College District, Davenport, Iowa. Then we have John Hartwig, ex officio, Iowa Department of Education, Des Moines, Iowa. Now, this document itself is a little bit misleading because it starts out talking about this Memorandum of Understanding with Regional Workforce Development Center. So if you were to look at this document immediately without analyzing or looking through the whole thing, you would assume this is talking about something very specific. With the agreement of the chief elected official, will develop and enter into memorandum of understanding between RWIB and the RWDC partners concerning the operation of the RWDC delivery system in Iowa's 15 community college districts. Each MOU shall contain provisions describing the services to be provided through the RWDC delivery system, methods for referral of individuals between the RWDC operator and the RWDC partners for the appropriate services and activities. And in my past videos, I've talked about the cover term partner and services to mean something far more expansive. The duration of the memorandum and the procedures for amending the memorandum during the term of the memorandum. Regional Workforce Investment Board, RWIB, and Chief Local Elected Official, LEO. Of course, most of us understand LEO to mean Law Enforcement Officer. So that's kind of interesting. Adult dislocated worker and youth activities under WIA, Employment Services. Adult Education and Family Literacy Act. This is under the listing required partners. Post-secondary vocational education under Perkins 3, vocational rehab under WIA, welfare to work, Title 5 of Older Americans Act, Trade Adjustment Assistance, NAFTA, TAA, Veterans Employment and Training Programs, Community Services Block Grant, HUD, Administered Employment and Training Programs, Unemployment Insurance, Local Board and Local Elected Official, LEO, may approve participation by the programs. And of course, we all understand these at this point anyway. All of these are cover terms. They are the pretext with which these entities do what they do in a very destructive manner and with intent. Title II services to be provided through the Regional Workforce Development Center. Core services include information on supportive services, cost information with respect to local providers of literacy services. And of course, we know that when they refer to somebody as illiterate, they're doing so in a derogatory way. And so this literacy service stuff is actually a cover term for how they're going to approach everyone else, as it were. Intensive services, comprehensive assessment of skills and service needs. And service being another cover term. Student competency-based learning gains reports provided to sponsoring agencies. As a required RWDC partner, the Iowa Department of Education must ensure funds made available is used or are used by providing services or through other means to create and maintain the RWDC delivery system. The Partners Program, and that also brings about something, the Partners Program is also something that's well known in YouTube and various other platforms. And the term partner and partnership is another cover term that we covered in the previous videos, and it's used to essentially mean their operating elements within the system. Other related considerations such as how the system is used by attributable individuals. It's an interesting word there, attributable individuals. The Iowa Department of Education or its RWDC partner and designees community colleges must ensure that funds be used by providing services or through other means to create and maintain the RWDC delivery system. So that's repeated. And when you find a phrase repeated, there's a reason for it. Support for the core services and for operating costs may be in cash or in kind contributions, money laundering. The RWIB has the authority to amend the MOU based on input from mandated partners, other agencies, etc. Failure to execute an MOU. Now here's the nice one that's cloaked in a lot of irritating cover terms. UASDOL, Regulation Section 20 CFR, blah blah blah, requires that the local Title II provider and RWID enter into good faith negotiations to execute an MOU that meets the requirements of Title I. Title II provider must document the negotiations efforts that have been undertaken to execute a regional MOU. In the event that an impasse in negotiations develops, the Title II provider may request assistance from the Iowa Department of Education in resolving the impasse. Yeah, assistance, haha. Title II provider must inform the Iowa Department of Education if it has not been able to execute a regional MOU with the RWIB. The Title II provider may not serve on the RWIB if it has failed to execute a regional MOU. Any region in which the RWIB has failed to execute an MOU with all required partners is not eligible for WIA Title I incentive grants awarded on the basis of local coordination of activities. And as we see again, the funding leash is applied here. Sources of information: Iowa State Plan for Adult Basic Education fiscal year 2000 to 2024. The Iowa Department of Education approved local adult basic education plan. So, of course, they're talking about quote-unquote adult learners, which is essentially everyone that they claim jurisdiction over, which is everybody. Common literacy services included in the local MOU, providing adult learner progress reports utilizing the TOPS Pro software. And here we get the big one. Insight, a Think College brief on policy, research, and practice. So, the first thing that we read was a document specific to a particular element. But then we come in the same document, mind you, this is listed under the Ed 438408 document. And there's no mention of this secondary document behind it. Insight, a Think College brief on policy, research, and practice. In this brief, we use the term MOU, but a similar interchangeable term is Memorandum of Agreement, MOA. MOU and MOA are both written agreements between two parties. There is no established legal difference. Parties can decide which term to use depending on their preferences. So first we need to talk about the term legal. Legal has become ubiquitously used for both lawful and legitimate. That is because the corporations that run everything today can only recognize that which is reduced to writing, and that is what legal means. Legal can be unlawful and it can be illegitimate. It is, simply speaking, a document, something that is written. Well, a corporation made out of paper cannot recognize anything beyond writing, beyond other paperwork. They cannot recognize human events or other happenings in reality outside of that singular sphere. As anybody knows, all corporations, all governance structures of business entities, they all revolve around paperwork alone. And because we have for-profit corporations pretending to be government at the behest of academia, who is the planning and research and intelligence section of the whole structure, and possibly even be the main operators, it's hard to say. Either way, they all conform to the concept of everything being on paperwork alone, because that's all they can recognize functionally. And thus legal has become pervasively used in taking everything apart, whereas in the past, many other court systems existed that accepted things beyond simple paperwork. So that's the reason why we're talking about legality here and legal, and the idea of a legally binding document. MOU are less formal than contracts. Organizations may choose MOU over contracts for the simplicity and flexibility. However, institutions of higher education, IHEs, agencies, and school districts may still treat an MOU as if it were a contract, involving their legal teams or departments in the process. So there you see this repeated phrase that a MOU is not a legally defining contract or whatnot, legally binding. But here they basically state that it actually is. More twisted words, cover terms, acting in one way but meaning the other thing. Either party may initiate MOU development. Once the first party approves, they send the MOU to the other party. Both parties may engage in negotiations over wording or sections to add or delete. After these negotiations, both parties finalize and receive a copy of the final document to sign. The MOU does not take effect until both parties sign. These elements are very likely to be included in any MOU. Descriptions of each entity and partner, each party that will sign the MOU, purpose of intent, mission, first sections of the MOU outlining the intentions of the parties involved, benefit, how the collaboration/partnership benefits each entity, and it used to be that the word collaborator meant somebody who's collaborating with the enemy, and that was not something you wanted to be. Terms, date range, responsibilities, essentially the reason for the MOU, entity contracts, and signatures. These additional elements may be useful in certain circumstances: resource contribution, evaluation, liability, amendments, assignment, and disclaimers. Insight is a publication of Think College at the Institute for Community Inclusion at University of Massachusetts, Boston. This insight brief was developed by the Think College National Coordination Center, which is funded by a grant from the Office of Post-Secondary Education, grant number P407B200001. Now, interestingly enough, we have the ERIC Yellow Dot program between bus contractors and school district. Implementation of the Yellow Dot program and proper training and education to exceptional learner parents/guardians in regards to the ERIC form. Let's see what this is about. ERIC stands for Emergency Response Information Card, and many other things. The ERIC form will contain important information an emergency medical responder will need to help care for the special children during an emergency. The ERIC form will be secured in the bus in a yellow box similar to that size of a body fluid kit that is locked/sealed with a zip tie. The box will display a message prohibiting unauthorized entry and disclosure. So that kind of interesting that how specific it is. The ERIC Yellow Dot program will serve as a communication tool within our state to ensure a child's complete medical history is concisely summarized and available when needed the most when the child has an emergency health problem and emergency responder needs medical information to render care. It's also good probably and definitely used for other types of communication purposes. The school district will be responsible for the collection of information to be placed on the emergency response information card. The school bus contractor will ensure that the emergency response information cards received from the school district are promptly put in the yellow box that has been specifically created for the ERIC form. This MOU may be modified by mutual consent of authorized officials from the school bus contractor and the school district partners. And this has partner name, it is unsigned, so that's not exactly the signed document. Moving on, we have, now that we've established the primary functional focal point of academia, and that they're specifically the originators, here we have Collaborative on Administrative Data, the United Nations DESA statistics. Guidance and template for developing a memorandum of understanding to help improve coordination and cooperation within the national statistical system and increase continuous access to administrative data for statistics production. Data. It is important to, and that's funny because Data is the name of the android in Star Trek, The Next Generation. It is important to determine the scope and nature of the data to be shared. That is, will the agreement only cover aggregated data and indicators, aggregated means added together? Or will microdata with some or all variables collected, including identification ones, be shared, for example, quality checks, calculations, and or analysis to be performed at the NSO? The sharing of microdata is overall recommended where possible, but is naturally also associated with considerations of confidentiality, and appropriate provisions must be made to safeguard the privacy of individuals and entities. Table 1 in Chapter 2 of this document exemplifies elements to be considered in the MOU depending on the type of data to be exchanged. Other elements that could be included in the agreement that give more details on the variables and data to be shared are the description of the data, the periodicity of the data collection and exchange, the format, and the means of transmission. This could be detailed more in an annex, as exemplified in Annex 2 to this document. Confidentiality and security. This section is always included if microdata are shared between the parties. It specifies the legal obligations, again reduced to writing, so on paper, of the NSO when it comes to keeping the data received confidential. This should include both obligations of employees who will be working with the data, as well as ensuring that the physical and IT infrastructure at the NSO premises are sufficiently secured to prevent third-party access. There are 5 principles that some NSOs embedded in the instruction for data sharing to guarantee confidentiality, and that can be of inspiration to countries. See, for instance, Australia Government 2019, UK Office for National Statistics. People, project settings, outputs, and data. Only those staff who are responsible for producing statistics with this confidential data have access to the data. People. The data shared will be exclusively used for statistical purposes, and the purposes might be explained in the agreement. Projects. The data should be transmitted, managed, and stored in secured environment settings. The outputs, the statistical production maps, tables, leaflets, etc. cannot directly or indirectly identify the data subjects. Outputs. Data that could be further used for analysis or research purposes will not make possible to identify the subject's data. MOUs might specify security requirements that the NSO should follow as agency receiving the information and the custodian of the data security. The example below details different security aspects that should be fulfilled by the NSO. It covers different aspects such as physical access to the data, IT storage, and transmission requirements, physical storage of the data, and copying and retention management. Examples from MOU between Statistics Canada and the National Energy Board. Servers storing and transmitting unencrypted data where used will be located in a secure controlled access area, preferably in the same area where the information is accessed. If located in a separate area, controls will be in place to ensure that only identified persons can access the server. Unless the information is encrypted continuously while outside the secure area, a conduit will be used for all cabling and all cross-connect areas will be physically secured. Connect areas. Network firewalls and access rules will be in place to prevent access to the information other than to identified persons. Information may be stored and transmitted over networks not meeting these requirements, provided that it is encrypted, except when at rest and in use by an identified person. Alternatively, the information may be stored on a standalone computer in a secure area with no external connections or on a closed network within the secure area. When the network transmits information that leaves a secure area, for example, when a series of buildings house employees within a single organization, the information will be encrypted whenever it is outside the secure area. Amendments section. Well, I think we know what the amendments section is about. Use of the information. This clause specifies the use of the information collected from the data holder. Most of the countries do allow for using the data for research purposes. On some occasions, the agreements contain specific information that defines the statistical and research purposes allowed to define the uses and detailed outputs. And of course, as we know from previous videos, research is another cover term. Clarification of administrative or regulatory purposes. Use of information or administrative or regulatory purposes means use of confidential statistical outputs in the decision-making process that directly affects the respondent or any other person. This applies to all phases of work for statistical purposes. Finally, it should be noted that unless otherwise explicitly included in the MOU, the receiving agency, the NSO for instance, is not allowed to transfer the data received to a third party when the latter is requesting it, even if it is appealing to the access to public information law. If this were the case, the third party should be directed to the original data holder, which remains as custodian of the administrative data. Of course, all of these are methods with which they can set up a variety of clandestine databases for their personal use only. That is the important distinction. These are corporations pretending to be governments who treat all others not in their organization, and even those in their organization they treat with distrust, but all others are outsiders to their structure. This is theirs, not ours. They are not friends and they are not allies. They do things for their own purposes as specified in these documents. Writing Guide for a Memorandum of Understanding, MOU, Homeland Security, SAFECOM. We're going to find similarities anyway, to what we just read there. Introduction. The introduction section of the MOU helps the reader to understand the agreement content. And there you get the other word, the Memorandum of Agreement, but it doesn't say MOA here. It just slyly drops it in there. It describes the need of the agencies involved, why it is necessary to work together, etc. This section should be a simple explanation of the agreement and why it is necessary. It does not need to include details about past efforts or discuss how the agencies reached the level of agreement. For what capability or resources is this MOU being created? What agencies are participating in the MOU, including public safety agencies, other governmental bodies, and any private services? Purpose. The purpose section should be a concise statement discussing the intention of the new or proposed capability that makes the MOU necessary. It explains how the agencies will use the new capability under what circumstances, what is intended, the level of command, when it will be used, how it will be used. Scope. The scope section lists agencies and jurisdictions to be included in the agreement and describes their relationships. This section can also discuss end users, level of command, level of government, voice or data, etc. Who are the public safety, public service, and other governmental and non-governmental agencies that will use a capability/resource? What is the authorized user command level for the capability/resource? Definitions. The definition section describes the operational and technical terms associated with the capability or resource for within which the agreement is written, providing definitions to help avoid confusion and uncertainty. What are the technical and operational aspects of the capability resource? Consider including definitions for each. Are there any community-specific terms or acronyms? Consider including these acronyms in definition. The policy section of the MOU briefly describes circumstances under which the capability can be used. This section can also mention authorized use, activation timing, and other circumstances. When can the capability resource be used? When should the capability resource be considered for use? Who has the ability to authorize use of the capability/resource? Are there operating procedures associated with this capability/resource, and can specific procedures be referenced? User procedure requirements. This section outlines the obligation of the agreement. For an agreement on sharing and enhanced capability, obligations may include training exercises, user requirements, responsible parties for ensuring the training, and awareness. What are the training, exercise, and equipment requirements associated with participating in this MOU? Are there additional requirements? Are there any financial obligations that must be considered? Maintenance. The maintenance section designates a responsible party or parties for maintaining equipment, systems, and licenses. The maintenance section can name a jurisdiction, agency, or individual. What are the maintenance requirements associated with participating in the MOU? Who will own the license and who will maintain the equipment? Oversight section describes how agencies or jurisdictions will deploy the new capability. It also describes how the agencies can provide recommendations that affect policy and whether other agencies accept or reject these recommendations. A description of internal agency policy regarding usage of the capability can also be provided. What governance structure oversees the use of this capability/resource and enforces all requirements of this MOU? Who is the chair of this governance structure and how is he/she appointed? What are the participation requirements in this governance structure of agencies entering this MOU? How are issues affecting policy recommendations and or subsequent change implemented by the governance structure? What is the voting method within the governance structure, and how do individual agencies establish oversight authority for the capability/resource? And then the last page, responsibility of SOP compliance. This section assigns responsibilities to agencies to ensure standard operating procedures, SOP for the capability, are forwarded or followed. Who is responsible for ensuring the SOP's association with this capability resource are followed and that individual agency personnel are trained appropriately? How will compliance be carried out? Updates to the MOU. This section describes how updates can be made to the MOU. It includes information such as who has the authority to update the MOU, how updates will be made, how participating agencies will be notified of updates, and the types of updates that will require signatures of all participating agencies. Who has the authority to update/modify this MOU? How will this MOU be updated and modified? Will updates/modifications require this MOU to have a new signature page verifying the understanding of changes by each participating agency? So now we essentially looked at the guidelines of MOUs and where those come from. Who is essentially speaking writing the regulations on memorandums of understanding? Where does that knowledge come from? And the next thing we're going to look at is how MOUs are applied. After that, we'll start looking at some memorandums of understanding and what they mean in practice. City Council Agenda Report, meeting date June 4th, 2013. Operation of the City of Costa Mesa's Jail, May 29th, 2013. Office of the Chief Executive Officer. Thomas R. Hatch, Chief Executive Officer. It was determined that contracting out the operation of Costa Mesa jails was worthy of exploring because based upon the feedback obtained during the evaluation conducted pursuant to Council Policy 100-6, it was determined that contracting out could result in better jail operations at lower costs. The CEO issued request for proposal RFP number 9.21 for operation of the Costa Mesa Police Department's Type 1 jail facility. It was determined that the lowest and most qualified bidder was G4S Secure Solutions, G4S. What a surprise there. Not to mention G4S, we've done a very extensive video on them and how they relate to essentially the Wackenhut Corporation, which is owned by an overseas entity in Denmark and is specifically a element of the CIA. May 15th, 2012, Council approved a contract between Costa Mesa and G4S pending the resolution of the city's outsourcing constraints. Pursuant to Article 14 of the Memorandum of Understanding. Pursuant to Article 14, that's like referencing an article in the Constitution or any other thing like that, of the Memorandum of Understanding. That is referencing a Memorandum of Understanding as though it were in fact concrete law, unquestionably, in place between Costa Mesa and the CMCEA concerning the costs of providing jail services and the development of effective work practices for jail services going forward. Costa Mesa remains open to the possibility of allowing any employee currently working in Costa Mesa jail to transfer into the Y-related positions, or rated positions. And Costa Mesa will continue to work with the employee representative of such employees to achieve those transfers if requested. They're attempting to do a quiet transfer of these elements. The city's Type 1 jail facility is currently staffed by 7 full-time custody officers and 1 full-time sergeant. In addition, there are currently 3 part-time custody officers. Included in these services the necessary work of a court liaison officer. The city's FY 2012-2013 budget for jail staffing is $1,346,789, and the proposed staffing cost for G4S is $740,329. I'm sure they make up that money and more as well. The significant savings of $603,460 annual comes from G4S paying lower hourly wages and reduced benefits compared to city personnel. That does not sound like a government structure. That sounds like a for-profit corporation, doesn't it? G4S provides a commitment of 440 hours of service per week and fills vacancies in their staffing with Flex Force staff to ensure all shifts are covered. Isn't that a nice name they made for it? Flex Force. Sounds like some weird cartoon crap that it came out of Disney Channel. The city will realize additional savings by G4S, providing a layer of liability protection in a potentially high liability service area. That's a nice way of putting it. The police chief has contacted several jurisdictions that utilize G4S and has received positive remarks about the quality of their service. What a surprise. Risk 360 Incident Management System. This provides documentation and accountability of jail operations and events, and probably facilitates many scams as well. This is web or smartphone based. This will require an annual fee of $4,976. Staff will immediately review the benefits to make final determination before authorizing this additional cost. Automated HR systems and billing, a client-based attendance and billing system, and an online time and attendance system for staff. Automated tracking system that records cell check date and time using a smart device. Oh, that's not something we've seen before at all, no. Why on earth would they want to make everything automated, I wonder? Maybe so somebody, say in Denmark or Germany or wherever else, can practically control this entire thing in California all the way away. As far away from the consequences of their nasty activities as possible. Part of this transition would be to retain the police sergeant position as a supervisor over the jail for a period of time, likely a full year. After a period of time, the need for the sergeant position will be reevaluated and likely transferred in whole or a large percentage of time to another area of the department. The CO is seeking council's approval to continue to develop a transition plan and will administratively implement this plan. A transition period will commence, and G4S will likely need 2 months to gear up for the first day to ensure a smooth transition. In addition, city management will need to implement an employee transition plans that have been developed with input from employee associations. Staff will also meet with impacted employees and ensure compliance with any and all requirements per our labor agreements and state law. Notice how they say our labor agreements and state law. In short, the contracted provisions for the provision of services related to the administration and management of the city jail by G4S personnel, procedures, and technology systems. The contract costs will include laundering and jail cleaning, as well as overseeing existing and future city contracts for food service, cell repair, telephone services, and the like. As well as overseeing existing and future city contracts for food service, cell repair, telephone services, and the like. That doesn't sound like this is just limited to the jails. Here we go again. Article 14 of the MOU and Council Policy 100-6, with both of which Costa Mesa has complied, further authorize Costa Mesa to contract the operation out of its jail. Well, isn't that nice? They gave themselves the authority to do whatever they want. What a surprise. Thomas R. Hatch, Chief Executive Officer, Thomas Ghazi, Chief of Police, Bobby Young, Director of Finance and IT, and Kimberly Hall Barlow, Special Counsel. One has to wonder if those names are even real people. Moving on to the Memorandums of Understanding, let's first start with the section on technology and information. This exhibit must be read together with the MOU. I couldn't actually obtain the MOU. This is Government Technology Agency, Exhibit C, Additional Clauses and Information for Apex Cloud. Apex Cloud is a centralized API management solution that helps agencies to simplify the management, security, and adoption of their APIs. It includes the API Gateway, API Manager Portal, API Developer Portal, and other products that may be offered by Apex Cloud. The service requires the use of TechPass and Seed. Terms are often found here, TechPass and here Seed, and you shall comply with them. Upon termination of the services or this MOU, all the agency's data, user accounts, and access APIs, API subscriptions, applications, etc. related to the services will be deleted and wiped away. That is what in the intelligence community is referred to as I don't remember what the term is actually, but you get an enemy that overruns your position in the intelligence community, and your primary purpose is the planned destruction of everything you have so it doesn't fall into enemy hands. And that's exactly what they're talking about there. Because we are their enemy. Or, I guess they more like consider us as products of their corporation. I guess the product could become an enemy in this concept. The agency may make a request to change its requirements to the Engineering Suite console or the Services portal. If GovTech were to accept the request, GovTech will confirm the request through the Engineering Suite console. You may view it through the platform for your records. For clarity, such change in requirements will not require the parties to re-execute the MOU. The agency warrants and represents that subscription administrators have the authority to bind the agency at all times. This document itself sounds like it's being pushed through an automated system itself. Notwithstanding the above service level targets and service availability, the agency using the services shall review the Business Continuity Plan, BCP, Disaster Recovery, DR, plans to ensure that their operational needs can still be met. Uses or allows software from third-party providers, Axway Amplify API platform. The services shall not be used for software or information classified confidential or above. Services shall not be deemed to include any and all APIs published on or any third party. The next one we have is Memorandum of Understanding, Investment-Based Participants in Advanced Research Computing for Computing Use. Virginia Tech Researcher, Advanced Research Computer ARC, High Performance Computing HPC Investment Computing Program. And this specifies over a 5-year term of this MOU. That's something we'll find repeated pretty much on all of these MOUs or MOAs, whatever you want to call them. But most of these are titled MOU. Is that they all ubiquitously just about have the term of 5 years. Some variations here and there. Storage Service Unit, SSU, 1 terabyte of available storage. Computer Service Unit, CSU, 1 processor core. Priority access will be granted to the participating faculty partner and their research team, which includes any students, postdoctoral researchers, and collaborating faculty specified by the faculty partner. This section here is repeated. That specific phrase about priority access. Advanced research computing responsibilities: establish and maintain user accounts and job submission queues, provide information regarding system maintenance outages and system status via email to all users, including the faculty partner. There's another section that's repeated here that's important to point out. And this says, protected by federal security or privacy laws, unless an exception has been negotiated explicitly. Accept responsibility for any data curation and retention costs associated with data stored on the HPC file systems that must be supported beyond the 5-year duration of the MOU. Oh, this lists faculty partner responsibilities. Request user accounts online using ARC count request form. Planned maintenance windows will be announced at least 1 week in advance. It is not intended for data protected by federal privacy and security laws without special arrangement. Responsibility of the faculty partner is her research team and IT staff to comply with all Virginia Tech and Commonwealth of Virginia policies and standards. Questions about information security can be directed to ARC by submitting a consultation request. The HPC file systems are housed at Steger Hall, 1015 Life Sciences Circle, Blacksburg, Virginia. Incident report, the ticketing system, V24 Help. This software is configured to provide privileged access to the faculty partners research group. Priority job queue is configured to ensure that faculty partners' queue jobs are scheduled ahead of queue jobs submitted by non-investing users until the annual limit of priority CSUs purchased in this agreement is reached. The faculty partner may continue to use this priority queue once the annual limit of priority CSUs has been exceeded. Support for protected data must be negotiated explicitly between the faculty partner and ARC. Long-term storage is available via the archival storage system, which includes off-site backup. In the event of termination, all equipment will remain the property of ARC. The faculty partner may sell or transfer the remainder of his/her access to another Virginia Tech researcher. ARC will facilitate the transfer to the new partner. Alberto Cano, Associate Vice President for Advanced Research Computing. Sharon Pitt, Vice President for IT and CIO. And then on the next side is just name. No actual person name there. Next we have PNLL-UW Memorandum of Understanding on use of campus space as temporary location for the Joint Northwest Institute for Advanced Computing, NIAC. University of Washington, UW, and Battelle Memorial Institute, Pacific Northwest Division, Battelle, the contractor operating the Pacific Northwest National Laboratory, PNNL, on behalf of the U.S. Department of Energy, DOE, under contract number DEAC0579RL01830. Use of UW campus space, specifically the Suite Sieg Hall 127, temporary location. Signed on December 2011 by Stephen F. Ashby, Deputy Director for Science and Technology, on behalf of Battelle Memorial Institute and UW Vice Provost for Research Mary Lindstrom. Temporarily located on the UW campus in Sieg Hall Suite 127. Room 127A is shared between the parties. The corridor labeled 127Z is also shared between the parties. The corridor is used to access room 125, which is a server room that supports both computer science and engineering, CSE, and UW electrical engineering, EE. Access to the server room 125 via the entrance to main suite 127 and the corridor 127Z. And here you can see a layout diagram. The suite is currently under renovation to make it suitable as temporary location for NIAC. Personnel located in this space must be members of the NIAC, jointly selected by the parties based on the criteria described in the technical MOU document mentioned above in Section 2, Item 3, and hold UW appointments described in the personnel MOU document mentioned above. Non-UW affiliated PNL personnel shall not be permitted to use this space except for scheduled meetings with NIAC members. All personnel using this space shall abide by the health, environment, safety, security, and training requirements for the space. Any modification of this space must be authorized in advance by the UW via the College of Engineering, COE, as the UW representative and paid for by PNNL. Modification shall be included as addenda to this space MOU. The current renovation proposal is included as Addendum A. Start date is the move-in date, February 11, 2013. Temporary location is 2 years. Extension of this period limited to maximum of 1 additional year. Parties will jointly make good faith efforts to find off-campus space, preferably close to UW campus, to serve as permanent NIAC location. Notwithstanding the above, in the event of an imminent risk to health, safety, or security, the terminated party will immediately suspend access to the space described herein. Naturally, any notice under the MOU shall be in writing and shall be hand-delivered, mailed via the United States Postal Service, or delivered via nationally recognized expedited delivery service to the contract administrator of the party receiving notice, to wit, PNNL Contract Administrator Bruce Simanton, Contracting Officer, Pacific Northwest National Laboratory, P.O. Box 999 MS, J1/15, Richland,99352, telephone 509-371-7608.
UW Contract Administrator, Director of Sponsored Programs, Office of Sponsored Programs, University of Washington, 43333 Brooklyn, 4 and 33. Brooklyn Avenue Northeast, 17th floor, Box 359472, Seattle, Washington, 981959472. Telephone 206-543-4043. And then the governing law and signature is to be added later. The next document gets into a little bit of a different topic. And that is the use of this term nation. See, this is very important for certain nations or nationals out there. Being the use of the term nation by most is understood to mean the people versus the country, which is supposed to be in reference to the land. However, the way these corporations use the term nation and country is very different. But specifically looking at the word nation, they steal the name of nations. So what that means is you take a corporation and you name it such and such nation. And then when you refer to nations or national security, that is the nation to which you are referring. You are referring to the juridical entity name, not the people in that nation. And that's how you steal the name of nations. Interestingly, this says consultation on implementation of MU. Suppose you could take out the O and still get memorandum of understanding, but this is not MOU, it's just MU. However, Tribal Treaty Rights Memorandum of Understanding, September 16, 2022, attended via Zoom webinar. Olender Reporting Incorporated, schedule at olenderreporting.com. 866-420-4020. Consultation attendees, Brian Newland, Assistant Secretary of Indian Affairs. Avita Boyd, no listing of office or reason for being there, just the name Avita Boyd. Darren Carrero, Senior Policy Advisor for Native Affairs. Jane Nishida, EPA Assistant Administrator, Office of International and Tribal Affairs. Heather Dawn Thompson, USDA Director, Office of Tribal Relations. Melanie Benjamin, Chairman, Millocks Band of Ojibwe. Matt Dannenberg, Department of Energy. Sandra Sampson, Treasurer, Confederated Tribe of the Umatilla Indian Reservation. Farron Jackson, Chairman, Leech Lake Band of Ojibwe. Joffrey Standing Bear, Principal Chair, Osage Nation. Jared Hautamaki, White House Counsel. Kim Teehee, Cherokee Nation Delegate. And Mario Gonzalez, Tribal Counsel, Oglala Sioux Tribe. Implementing the Tribal Treaty MOU from a perspective of information, USDA and DoD would combine financial resources to partner with the Oklahoma State University to create an online tribal treaty database. It is still in beta format. And this is from 2022. We are starting to organize it by state. Our BIA employee or Forest Service employee, and this is an example, let me pull up which treaties apply to them, so at least I can start from a place of an educated conversation. This is going to be a comprehensive database of everything that you would need to know so that there is no excuse. So let's put this into a little bit of a context. You have a corporate entity out there for the purpose of this next document, naming itself the Osage Nation. And because it names itself the Osage Nation, it states that all things in reference to the Osage Nation apply to it. You take an old document, and it states that this is the property, the land of the Osage Nation. And that old document is referring to the people. And then along comes a group of individuals, and they say, we're going to establish a trust or a company, and we're going to term it Osage Nation, so that way they can subsume everything in those older documents that was referencing the Osage Nation. And that's how they steal things. Memorandum of Understanding and Cooperation between the Osage Nation, the corporate one, not the people, and the U.S. Department of Energy's Office of Fossil Energy and Carbon Management, Office of Resource Sustainability. Memorandum of Understanding, MOU, Osage Nation, U.S. Department of Energy, Office of Fuel and Carbon Management, Office of Resource Sustainability, or DOE-FECM. Mutual intention to provide needed technical assistance, share data regarding undocumented orphan wells, enhance coordination, collaboration, maximize the benefit of both public and private investment, development of an equitable energy future. This is extremely important for the Osage. That's because you have something called a head right. Now, originally, the Osage Nation controlled an area, and I don't mean controlled in the usual territorial land ownership concept that has been imposed on us by these corporations pretending to be governments. But rather, they had this area that they controlled, and they found oil in an area in a time when oil was an important commodity. I mean, they probably knew it was there to begin with. And so families, originally families within the people of the Osage Nation in reference to the people, those families had an elder sitting at the head of the family. Could be a woman, could be a man, usually a man. But either way, the oldest person in the family is the head of the family. Those elders got together and decided things, and that's where you get the head right from. It is inheritance of oil money. Then you get a corporation that comes in and they murder all of the elders and everybody who's alive, and then they usurp the name Osage Nation and then say, we are here to administer these oil rights because they're ours, because the documents originally signed by the elders of the head rights named the Osage Nation, and that's what we are calling ourselves. And that's what happened here. So now they want to shut down what they're calling orphan wells, because they have the authority based off of the name Osage Nation. Alongside the DOI efforts, DOE FECM was directed to allocate $30 million over 5 years to identify and characterize undocumented orphan wells, UOWs. The Osage Nation enters this MOU under Article 7, Section 1 of the Osage Nation Constitution, ratified by the Osage people on March 11, 2006, and signed into law May 6, 2006. Now, as we know, as I just stated before, the Osage Nation they're talking about is the corporate structure. The Osage Nation Constitution is the corporate constitution, and the Osage people referenced here are those few people that are listed as the agents or corporate representatives of the Osage Nation Corporation. Develop, collaborate on, and share informational materials and data that can foster Osage Nation community awareness. I think we know what that means. The MOU is effective on the day of signature of the Osage Nation and DOE-FECM and shall thereafter remain in effect for a 5-year period unless renewed in writing at least 30 days before the expiration of the MOU. Termination of this MOU does not require either party to return information that the other party has already transferred to it. Well, isn't that nice? This MOU is strictly for internal management purposes only for each party. This MOU constitutes a final understanding of each party and all subjects contained within it. All prior negotiations, understandings, and agreements merged into this MOU. Ryan Pay, Deputy Assistant Secretary for Office of Resource Sustainability, August 29, 2023. And Joffrey M. Standing Bear, Principal Chief, Osage Nation, July 17, 2023. The usurpers doing their usual bang-up job of stealing people's stuff, driving them into poverty, and then consuming everything that they possess, own, will make, and of course, going after their children. Oklahoma State Bureau of Investigation Government Transparency Act of 2019 report, Memorandum of Understanding, OSBI, Internet Crimes Against Children, ICAC Task Force, and Osage Nation Police Department. January 21st, 2025. It is indefinite, to outline the relationship between all participant agencies in order to ensure that each understands and agrees to guidelines concerning policy, supervision, planning, training, and public relations. This reference is under legal authority, DODI 4000.19. Now the next document is Memorandum of Understanding between the U.S. Department of Labor, Wage and Hour Division and the Oklahoma Employment Security Commission. DOL-DWHD recognize the value of establishing a collaborative relationship to promote compliance with laws of common concerns among the regulated community in the state of Oklahoma. This MOU agreement outlines procedures to be followed in working together to address the need for compliance among the regulated community and the rights of workers with regard to employment status and related protections, payment of wages, hours of work, safety, and health. DOL-WHD enforces other statutes for construction and for the provision of goods and services. OESC is responsible for the task of making employment relationship determinations within the state's workforce. This agreement replaces and supersedes any previous partnership agreement, MOU, between the parties. Nothing in this MOU agreement will be interpreted as superseding. That sounds contradictory. Exchange of information. In order to effectuate the purposes and provisions of this MOU, it will be necessary to exchange information which may be considered confidential. In exchange of information with both agencies are proceeding with the common legal interest is their mutual benefit. The agencies, this MOU agreement recognizes the importance of being able to provide information to other law enforcement bodies without waiving the privilege of otherwise protected material or make a public disclosure. This is repeated. There is a need for DOL/WHD and OESC to provide information to other law enforcement bodies without making a public disclosure. The exchange of information to one another pursuant to this MOU is not considered a public disclosure under the Freedom of Information Act. Confidential information means information that may be privileged or otherwise exempt from disclosure to the public or other unauthorized persons under federal and state laws. Confidential information may include the identity of persons who have given information to the agencies in confidence or under circumstances in which confidentiality can be applied. Any employee statements on enforcement files that were obtained under these conditions, internal opinions, policy statements, memoranda, and recommendations of federal or state employees, including but not limited to investigators, supervisors, any records that would otherwise not be subject to disclosure under laws, non-final intra- or interagency documents, information, or records covered by the attorney-client privilege and the attorney work product privilege, personal information protected by any relevant law or regulation, individually identifiable health information, and confidential business information and trade secrets. Neither party shall have the authority to waive any applicable privilege or doctrine on behalf of the other party, nor shall any waiver of any applicable privilege or doctrine by the conduct of one party be construed to apply to the other party. The agencies agree to establish a communication protocol for notifying each agency's designated POC when information is sent to or received from the agency, including information on the form of the transfer and the immediate type and quantity when appropriate. An agency expecting to receive information will notify the donor agency if the information is not received as the next business day following the agreed upon delivery date. Confidential data will be destroyed no later than 30 days after its use and may be transmitted via secure FTP. Confidential data will not be electronically mailed unless encrypted using approved encryption standards. In the event that the agency receiving the information experiences a security incident or disaster that results in the suspected or confirmed inadvertent disclosure of the data exchanged pursuant to this MOU agreement, the agency experiencing the incident or disaster will send formal written electronic notification to the donor agency's designated contact person immediately within 3 days after detection of the incident or disaster. The written electronic notification will describe the security incident or disaster in detail, including the data exchange pursuant to this MOU agreement may have been inadvertently disclosed. The agencies agree to jointly disseminate outreach materials to the regulated community when appropriate. This MOU agreement becomes effective upon the signing of both parties and will expire 5 years from the effective date. This agreement may be modified in writing by mutual consent of both agencies. 1st of April 2022, Beth R. Campbell, Southwest Regional Administrator, Shelley Zumwalt, Executive Director, Michael Spear, Oklahoma City District Director, and Michelle Britton, Chief Operations Officer. Next, we have Memorandum of Understanding between U.S. Department of Labor Wage and Hour Division and the National Labor Relations Board. United States Department of Labor Wage and Division and the National Labor Relations Board. This MOU agreement outlines procedures to be followed by both DOL/WHD and the NLRB in working together to address the need for information sharing, joint investigations, and enforcement activity, training, education, and outreach between DOL/WHD and NLRB. DOL/WHB and NLRB, or DOL/WHD and NLRB, may share, whether upon request or upon the agency's own initiative, any information or data that support each agency's enforcement mandates, whether obtained in the course of an investigation or through any other sources. This may include complaint referrals and other sharing of information in compliant or investigative files relating to alleged violation of the laws enforced by DOL/WHD and LRB. Any business models designed to evade legal accountability, such as misclassification of employees or when otherwise appropriate. That sounds familiar. DOL/WHD and NLRB responses to requests for information under this section shall not be made to the official who requested the information. The responding agency will provide copies of the requested documents or make the requested documents available to the requesting agency for inspection and copying and/or loan within 10 days of receipt of the request or as soon as practicable thereafter, consistent with the availability of the responding agency staff and other resources and the responding agency's own priority. Boy, they need to learn how to make grammatical structures. Confidential information means information that may be privileged or otherwise exempt from disclosure to the public or other unauthorized persons under federal statutes or laws. Confidential information may include the identity of persons who have been given information to the agencies in confidence or under circumstances in which confidentiality can be applied. Any employee statements and enforcement files which were obtained under these conditions, internal opinions, policy statements, memoranda, and recommendations of federal employees, including but not limited to investigators and supervisors. Any records that may otherwise not be subject to disclosure under law or non-final intra or interagency documents, information or records covered by attorney-client privilege and the attorney work product privilege. Personal information protected by any relevant law or regulation, individual identifiable health information, and confidential business information and trade secrets. Confidential information obtained pursuant to this MOU or any process established to implement this MOU is intended only for use and access by the receiving agencies for the limited purpose of carrying out activities pursuant to the MOU, or as required by applicable laws and regulations, except as set forth in this paragraph. Such information may not be used or disclosed by the receiving party for other purposes outside of the MOU or any process established to implementing the MOU to other authorities or any third parties unless the producing party expressly approves such or use or disclosure in writing. The information shall not be disclosed externally without a federal court order, a formal request from a federal oversight entity, or the supplying agency's written authorization stating there is no basis for withholding it, including but not limited to the confidentiality requirements of the Privacy Act. When responding to a federal court order, received agency shall notify and blah blah blah. Yeah, we don't really need to know the rest of that. Most of it is just nonsense, garbage, and you know exactly what they want to do. They want to cover up the heinous activities that they're doing above all costs, or by any means necessary. For information security purposes, information including paper-based documents and electronic information such as emails exchanged pursuant to this MOU remains the responsibility of the supplying agency while in transit. The agency agreed to establish a communication protocol for notifying each agency's designated POC or point of contact when information is sent to or received from the agencies, including information on the form of the transfer and the media type and quantity when appropriate. An agency expecting to receive information will notify the supplying agency if the information is not received as of the next business date following the agreed upon delivery date. Confidential data will be destroyed no later than 30 days after its use and may be transmitted via secure FTP. Use includes the time period required for compliance with federal records retention periods. Confidential data will not be electronically mailed unless encrypted using approved encryption standards. However, in the event that the agency receiving the information experiences a security breach that results in suspected or confirmed inadvertent disclosure of the data exchanged pursuant to this MOU, the agency experiencing the incident or disaster will send formal written electronic notifications to the supplying agency's designated contact person as soon as practicable and no longer than 30 business days after the detection of the breach. The written electronic notification will describe the security incident or disaster in detail, including what data exchange pursuant to this MOU may have been inadvertently disclosed. This MOU supersedes all previous agreements between DOL, WHD, and NLRB. This MOU will take effect immediately once signed by both parties and will expire 5 years from the effective date. On the signature, we have digitally signed by Jennifer Abruzzo, Abruzzo, date December 7th, 2021, General Counsel, National Labor Relations Board. And you have the Acting Administrative Wage and Hour Division, U.S. Department of Labor, Jessica Lumen, digitally signed December 8th, 2021. Next, we have Memorandum of Understanding between the U.S. Department of Labor and the Federal Trade Commission. United States Department of Labor and the Federal Trade Commission. This Memorandum of Understanding is to strengthen the agency's partnership through greater cooperation, coordination, information sharing, investigations, and enforcement activity, training, education, research, and outreach. By entering into this MOU, the agencies do not imply an endorsement or promotion by either agency of the policies, programs, or services of the other. Nothing in this MOU will be interpreted as limiting, superseding, or otherwise affecting the agency's normal operations or decisions in carrying out their statutory or regulatory duties or duties under any executive order. Nothing in this MOU modifies either agency's ability, responsibility, or obligation to comply with or enforce the laws and regulations within its respective jurisdiction. This MOU also does not limit or restrict agencies from participating in similar activities or arrangements with other entities. And of course, we know that that's just lip service and is essentially speaking a lie. The DOL designates the Assistant Secretary for Policy or other designee as the point of contact for matters related to coordination and cooperation pursuant to this MOU. The FTC designates the Director of its Office for Policy Planning or other designee as the point of contact for matters related to coordination and cooperation pursuant to this MOU. Coordinated investigations enforcement. The agencies shall establish procedures for consulting and coordinating various stages of their respective investigation enforcement activities with respect to potential violations of the competition and consumer protection laws enforced by blah blah blah. Where the agencies mutually determine it is appropriate, the DOL and FTT shall provide training to each agency's staff in identifying cases and issues that may arise under the other's jurisdiction. All public materials will attribute the authorship of the public materials to the respective agency or agency's public materials bearing the DOL name, logo, or seal must be approved in advance by the DOL. All public materials bearing the FTC name, logo, or seal must be approved in advance by the FTC. Like I said before, they are corporations for profit. They are in fact not government, as far as we understand that term to mean. It is the agency's view that sharing information in matters of common legal interest is to the agency's mutual benefit. Again, legal, documented. The agencies may, in their discretion and upon request from the other agency or upon the agency's own initiative, share information or data with each other that supports the other agency's enforcement activities, whether obtained in the course of an investigation or through any other sources, to the extent permitted by law, regulation, administrative or court order, or other restrictions and in accordance with applicable requirements and procedures. Such information may include complaint referrals and other information in complaint or investigative files related to alleged violation of the laws enforced by the agencies, as well as statistical analysis summaries in accordance with MOU and were not otherwise prohibited by law, regulation, administrative or court order, or other restrictions. The agencies will explore ways to sufficiently facilitate such information and data sharing, particularly in matters involving unlawful, anti-competitive conduct and unfair deceptive acts or practices, such as what they're doing here. When one of the agencies provides non-public information pursuant to this MOU, the providing agency to the other agency, the receiving agency shall presume the information to be confidential, non-public information, and shall maintain the confidentiality of such information in accordance with the terms of this MOU, unless and until the providing agency designates otherwise in writing. For purposes of this MOU, non-public information means all information in any format, including oral or electronic, shared pursuant to this MOU, unless the providing agency expressly consents to public release in writing or designates the information as publicly available in writing. Non-public information includes any communications or transmissions of information between the agencies pursuant to this MOU, including from a providing agency to a receiving agency, whether in written, oral, electronic, or any other form. Unless both agencies designate the communication or transmission publicly available in writing, non-public information may include the identity of persons who have given information to the agencies in confidence, blah, 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 and they repeat the same thing that we saw in all of the other documents. Well, the other two documents anyway. Requests for information under this MOU shall be made through each agency point of contact or others designated by them as necessary, and each agency shall promptly respond to these requests as appropriate and as soon as practicable, consistent with the availability of providing agencies' staff resources and priorities. Confidential protections and non-waiver of confidentiality and privileges. Unless applicable law requires otherwise, the agencies shall take all actions reasonably necessary to preserve, protect, and maintain all claims of confidentiality and all privileges and protections related to all non-public information provided pursuant to this MOU. The receiving agency shall not disclose to any third party that it has received information from the providing agency except within written authorization from the providing agency or pursuant to an order of a court of the United States or an official request or demand from either House or duly authorized committee or subcommittee of the U.S. Congress. Neither agency shall have authority to waive confidentiality or any applicable privilege or doctrine on behalf of the other agency, nor shall any waiver of confidentiality or an applicable privilege or doctrine by the conduct of one agency be construed to apply to the other. Non-public information may be obtained pursuant to this MOU or any process established to implement the MOU, is intended only for use and access by the receiving agency for the limited purpose of carrying out activities pursuant to the MOU or as required by applicable laws and regulations except as set forth in this MOU. Such non-public information may not be used or disclosed by the receiving agency for purposes outside of this MOU or any access established to implementing the MOU, or used with or disclosed to other authorities or any third parties unless the producing agency expressly approves such use or disclosure in advance in writing. The receiving agency shall not disclose to any third party that has received non-public information from the providing agency except with the prior written authorization of the providing agency or pursuant to an order of the Court of the United States or an official request or demand from the House or duly authorized committee or subcommittee of the U.S. Congress. Very obvious what they're doing here. Third-party requests. In the event of a third-party request in the event that a third party makes a request, including any demand request for production, interrogation, or interrogatory, request for admission, subpoena, court order, or FOIA request for access to or copies of non-public information received by a receiving agency from the providing agency unless otherwise prohibited by law, the receiving agency shall, for FOIA requests made by a third party for such non-public information, promptly refer requests for the providing agency's records to the providing agency for review and direct response to the requester. So basically, they're not going to provide it. For other such third-party requests, including request or subpoena that would fairly construed seek production of non-public information that received pursuant to this MOU, promptly notify the providing agency's agency point of contact in writing that such a request for subpoena has been received, so that the providing agency may file inappropriate objections or motions or take any other appropriate steps to preclude or condition the production of its non-public information. Before responding to or complying with any third-party requests, give the providing agency a reasonable opportunity to lawfully object or otherwise prevent disclosure to the third party and consent to an application by the providing agencies to intervene in a related action for purposes of protecting the providing agency's interests. Boy, they really don't know whatever they're trying to hide here getting out. They're very afraid. I'm sure it's very nasty and heinous, and they're hiding behind the protection of personal identifiable information. They don't care about that. They sell that to all these scam fraud companies out there. No, they want to protect something real and tangible related to what they're doing and the treason that they're engaging in. This MOU will take effect immediately once signed by both agencies and will expire 5 years from the effective date. Provisions related to the confidentiality and handling of information exchanged pursuant to this MOU shall survive the termination of this MOU. 30th day of August 2023. Signed, Acting Secretary of Labor, Julie A. Sue, August 30th, 2023. And Linda M. Kahn, Chair, August 30th, 2023 for the Federal Trade Commission.